Friday, the 12th of June, 2026. Federal Judge Catherine Morales just issued a travel restriction order against the sitting president of the United States. Docket filed at 9:14 a.m. Eastern. Case number 2, 6CR 487138 pages. Page 6, paragraph 12 states, "The defendant shall not depart United States jurisdiction under any circumstances while criminal proceedings remain active." Translation, the president cannot leave the country. Not for diplomatic summits, not for state visits, not for anything. Done. Signed. Enforceable. This isn't an ankle monitor. This isn't a standard bond condition you negotiate with a magistrate over a conference call. This is a federal judge telling a sitting president, the person who controls airports, borders, customs, Air Force One, and every diplomatic channel on Earth, that he is grounded. First time in American history, a president who can launch military operations anywhere on the planet cannot board a plane to leave his own country. Think about that for a second. The executive branch runs TSA, runs CBP, runs the FAA, controls every point of exit from U.S. soil. A judicial order now overrides all of it. White House responded within 9 minutes, called it unconstitutional overreach, a direct attack on presidential authority and national security. 9 minutes. They had the statement ready. They knew this was coming. Everyone's reacting to the headline. Cable news running split screens. Congressional leaders issuing statements. Social media losing its mind. Nobody's asking the right question. How did a federal judge get the legal authority to ground a sitting president? I went through the filings. Let me show you. Rewind 48 hours. Wednesday, June 10th. Most people weren't paying attention. They should have been. At 3:22 p.m., prosecutors filed a sealed emergency motion titled Petition for Pretrial Travel Restriction Flight Risk Assessment, 27 pages. I obtained a copy through FOIA Thursday evening. Page 8 is where it gets interesting. Prosecutors presented 4 pieces of evidence. First, scheduled presidential travel to Riyadh overlapping directly with the June 18th arraignment date. Second, private aircraft movements logged at Palm Beach International, 3 flights chartered to non-extradition countries between June 3rd and June 9th. Not Air Force One. Private charters. Third, communications obtained through warrant, showing senior staff discussing extended foreign travel with no return date specified. Fourth, financial transfers to overseas accounts totaling $2.3 million in the preceding 11 days. That's what prosecutors brought to the emergency hearing Thursday morning. 7 attorneys. Sealed courtroom. 4 one-minute session. Judge Morales asked one question. 1. Has the defendant taken any action consistent with intent to avoid this court's jurisdiction? Lead prosecutor responded with a single word, yes. Then walked through all 4 evidence points in sequence. Judge didn't interrupt once. Hearing ended at 10:48 a.m. Order issued Friday morning. That question, that one question, is what triggered everything you saw today. This didn't come out of nowhere. The machinery was already moving. Here's how travel restrictions work in federal court. Standard procedure. Defendant faces serious criminal charges. Prosecution argues flight risk. Judge imposes pretrial conditions. Bail, surrender of passport, restricted movement. Happens thousands of times a year across the federal system. Title 18, Section 3142, Judicial Authority over Pretrial Release Conditions. Judges have broad discretion. They can restrict travel, impose GPS monitoring, require check-ins. None of that is controversial. Until you apply it to a sitting president. Because now 2 constitutional authorities collide head-on. Article 2 gives the president control over foreign affairs. Diplomatic travel, treaty negotiations, commander-in-chief authority that requires physical presence on the world stage. The judiciary has authority over criminal defendants, all criminal defendants. The power to ensure a defendant appears for trial, the power to prevent flight. These 2 powers just crashed into each other in Judge Morales' courtroom. And here's what matters. This collision was only possible because of what came before. June 9th ruling established that presidential immunity doesn't prevent arrest. The Supreme Court's enforcement order confirmed courts can compel compliance from sitting presidents. Each ruling removed one more layer of protection: immunity stripped, arrest authorized, compliance enforced. Travel restriction is the next logical step in that sequence. If courts can arrest a sitting president, courts can restrict his movement. If courts can compel compliance, courts can impose pretrial conditions. The legal scaffolding was already built, brick by brick, over 14 months. By the time prosecutors filed that flight risk motion Wednesday, the constitutional framework was already in place. They didn't need new precedent. They used the precedent they'd already created. The prosecution knew this order was viable before they filed. They built the road that led directly here. Now here's where it gets interesting. Watch what the White House says publicly versus what they filed in court. Two completely different stories. Public statement dropped at 9:23 a.m. 9 minutes after the order, White House press secretary at the podium. This order is blatantly unconstitutional. No federal judge has the authority to restrict the President of the United States from conducting diplomatic travel. This is an attack on the office of the presidency itself. Defiant, absolute. Unconstitutional. No authority. Period. Now, read what Trump's legal team actually filed with the court at 2:15 p.m. that same afternoon. Emergency motion to modify pretrial travel conditions, not to vacate, to modify. Their argument isn't that the judge can't restrict presidential travel. Their argument is the restriction is overbroad. Page 4, paragraph 9. The order, as written, fails to account for essential executive functions requiring international presence. Read that again. They're not saying she lacks authority. They're saying she went too far in how she used it. That's a concession buried in 31 pages of legal filings. They've accepted the framework. They're negotiating the terms. Now, their strongest argument: national security. What happens if there's an international crisis, active military engagement, hostage situation, emergency NATO summit, and the president physically cannot leave the country? That's not nothing. That's a legitimate constitutional concern. And the prosecution knew it was coming. Page 19 of Wednesday's original flight risk motion includes a proposed national security exception clause. Prosecution wrote the exception themselves before the White House even raised the objection. They anticipated the strongest counterargument and built the solution into their own filing. The White House's best argument was already answered before they made it. Look, I'm going to be straight with you for a second. Everything I just laid out, the travel restrictions, the immunity rulings, the constitutional collisions, none of that is slowing down. It's accelerating. And while Washington figures out whether a sitting president can be grounded by a federal judge, the rest of us are still out here dealing with real life. Groceries are more expensive. Everything feels uncertain. The news cycle makes it worse every single day. So here's something actually useful. Amazon is currently giving away $750 gift cards to eligible US, UK, Canadian, and Australian residents. Free to claim, no purchase needed. Whether you use it to stock up on essentials while prices keep climbing, grab a few books so you actually understand the constitutional law behind what's unfolding right now, or just hold on to it for whatever comes next. That's $750 in real value sitting there while most people scroll right past it. Link is in the video description. Or open your phone camera, point it at the QR code on screen, and tap the link. Takes 30 seconds. While everyone else is arguing about headlines, go do something that actually benefits you directly. Now back to the case, because what prosecutors did next made the White House response look like a warm-up. Friday afternoon, 4:30 p.m., prosecutors filed their response to the White House emergency motion. Everyone expected a standard defense of the travel order, standard rebuttal, standard legal back and forth. That's not what happened. They didn't just defend the order, they expanded it. New evidence. Exhibits F through K. 6 additional filings nobody saw coming. Flight manifests showing the Riyadh trip was never coordinated through the State Department, no diplomatic cables, no advance team through official channels. Private scheduling communications between senior staff and foreign contacts with zero government function. Personal associates, business connections, not diplomats. Prosecutors reframed the entire narrative in 14 pages. This isn't about restricting presidential diplomacy. This is about preventing a criminal defendant from fleeing jurisdiction disguised as official travel. Saturday morning, emergency hearing. Judge Morales brought both sides back in. She had one focus, one. She turned to White House counsel directly and asked, was the president's scheduled travel to Riyadh coordinated through the State Department? Silence. 4 seconds. White House counsel responded, the travel arrangements were handled through the executive scheduling office. Judge Morales pressed, that's not what I asked. Was the State Department involved in planning this trip? Answer, no. Courtroom shifted. You could feel it. If the travel wasn't going through official diplomatic channels, it wasn't diplomatic travel. The national security argument, their strongest argument, their best card, collapsed in a single exchange. Judge Morales didn't say a word. She didn't have to. She wrote something down, looked at both sides, and scheduled a ruling for Monday morning. Zoom out. Forget the filings for a second. Forget the courtroom exchanges. Look at what just happened constitutionally. A sitting president of the United States was just classified as a flight risk under standard federal criminal procedure. Same legal framework applied to drug dealers, fraud defendants, flight risk CEOs. Same statute, same judicial authority, applied to the presidency. Constitutional law professor at Harvard, 28 years of scholarship on executive power, called it the most significant judicial assertion of authority over the executive branch since United States v. Nixon. Yale's Constitutional Law Department issued a joint statement. First time in 40 years they've done that. Now, the opposition argument, and it's serious. Former Attorney General Harold Morrison, constitutional conservative, put it this way. Restricting presidential movement effectively impairs executive function. The president isn't a private citizen. He's the head of state, he commands the military, he conducts foreign policy. Grounding him means any federal judge in any district, anywhere in the country, could theoretically paralyze the executive branch by restricting travel. That's not a fringe argument. That's a structural constitutional concern about separation of powers. The prosecution's framework is different. Criminal accountability requires the court's ability to ensure the defendant appears for trial. That's foundational to the entire justice system. If a defendant can avoid jurisdiction by claiming his job is too important, the system breaks. No office exempts anyone from that principle. Not governors, not senators, not presidents, expert consensus, and this is where it lands. Whether you agree with the order or think it's dangerous overreach, it's in the judicial record now. It will be cited. It will be referenced. It will shape every future case involving executive power and criminal accountability for decades. This precedent exists. It's not going away. 3 tracks, all moving, all connected, all converging in the next 10 days. Track 1, the criminal case. Trump is now a defendant under active travel restriction with hearings on a compressed timeline. Next court date, Wednesday, June 17th. Status conference. Prosecution wants to accelerate discovery. Defense wants continuances. Judge Morales has denied every delay request so far. Pattern clear. This case is moving fast, and she's not slowing down for anyone. Track 2, congressional response. Split down the middle, but not the way you'd expect. Senator Davis, Democrat, introduced emergency legislation Friday afternoon to codify judicial authority over presidential travel during criminal proceedings. Make it statutory, not just case law. Meanwhile, 14 House Republicans drafted a resolution condemning what they called unconstitutional judicial overreach against the executive branch. But here's what's notable. Senate Republican leadership hasn't signed on to that resolution. They're quiet. That silence is louder than any statement. Track 3, the appeals process. White House filed for emergency appellate review Saturday morning. D.C. Circuit agreed to hear arguments on an expedited basis. Oral arguments scheduled for Thursday, June 18th, 6 days from now. 3 judges on the panel. If the appeals court upholds the travel order, congressional pressure to legislate intensifies immediately. If Congress acts first and passes Senator Davis's bill, the appeals court may defer to legislative authority. If Trump's team wins on appeal, prosecution has already signaled in their Friday filing footnote 31, page 22, that they'll petition the Supreme Court for emergency review. These aren't parallel stories. They're feeding into each other. Appellate ruling affects Congress. Congressional action affects the court. Every track accelerates the others. All three converge by June 22nd. 10 days. That's the window where this gets resolved or becomes something nobody can control. Here's the timeline. Concrete. No speculation. Monday, full appellate briefing due from both sides. Prosecution files first, then White House responds by 5 p.m. Tuesday, amicus briefs from constitutional scholars, former attorneys general, and legal organizations. At least 7 already announced. Wednesday, status conference in the original criminal case. Judge Morales sets discovery schedule regardless of appeal. She's not waiting. Thursday, oral arguments at the D.C. Circuit. 3 judges, emergency basis. Both sides get 30 minutes each. Friday, appellate ruling expected. 3 scenarios from there. Scenario 1, appeals court upholds the travel restriction. Trump remains grounded through trial. White House petitions Supreme Court, but enforcement continues pending review. Most legally straightforward outcome. Scenario 2, appeals court overturns the order. Prosecution immediately petitions the Supreme Court, which has already demonstrated willingness to rule against presidential immunity in this matter. The prior enforcement rulings make the Supreme Court path viable. This buys Trump weeks, not months. Scenario 3, negotiated modification. Appeals court narrows the restriction, allows pre-approved diplomatic travel with judicial oversight. Both sides claim partial victory. This is the most likely outcome based on the pattern. 3 days of filings show a White House that's already conceded the framework and is negotiating scope. They shifted from unconstitutional publicly to overbroad legally. That's a team preparing to accept modified terms, not a team preparing for total war. But here's what matters beyond the scenarios. This isn't about one president and one travel order. This is about whether the American judicial system can ensure its most powerful defendant shows up to court. That question gets answered this week. Not theoretically, not in a law review article. In an actual courtroom with actual consequences. Here's where things stand. A federal judge issued a travel restriction against a sitting president. The White House fought it publicly and conceded the framework privately. Prosecutors expanded the case with evidence the travel wasn't diplomatic at all. Constitutional precedent is being written in real time, and it's not slowing down. Thursday's appellate arguments determine the next phase. And don't forget that free $750 Amazon gift card link is still in the description. Free to claim. Takes 30 seconds. Go grab it before it's gone. See you when the court rules.